This is a complex situation involving potential ethical and legal issues across family law and criminal proceedings. Here's an analysis of the key points. 1. Judicial duty to disclose. Generally, judges have an ethical obligation to report misconduct they become aware of, including improper attempts to influence judicial proceedings. However, the specific requirements can vary depending on the jurisdiction and the nature of the information. 2. Exculpatory evidence. Exculpatory evidence is evidence favorable to the defendant that could potentially exonerate them or reduce their culpability. The prosecution has a duty to disclose exculpatory evidence to the defense under Brady v. Maryland. However, this typically applies to prosecutors, not judges. 3rd, cross-case disclosure. There's no clear universal requirement for a judge in one case to disclose potentially relevant information to parties in a separate case, even if related. The judge's primary responsibility is to the case they're presiding over. 4th, ethical considerations. The judge did disclose the improper communication in the family law case, which was appropriate. Whether they have an obligation to report this to other authorities or cases depends on local rules and the specifics of the situation. Compelling disclosure. If you believe this information is crucial to your criminal case, your criminal defense attorney could potentially A. File a motion requesting the information from the family court judge. B. Subpoena the judge or court records, though this can be challenging due to judicial immunity. C. Investigate the alleged communication through other means. 6. Next steps. Consult with your criminal defense attorney about this information and its potential impact on your case. Your attorney can assess whether and how to pursue this information formally. Consider filing a complaint with the appropriate Judicial Conduct Board about the improper ex parte communication if you haven't already. It's important to note that while this information might be relevant to your case, it may not necessarily qualify as exculpatory evidence in the strict legal sense, depending on the specifics of your criminal charges. Given the complexity of this situation involving multiple cases and potential misconduct, it's crucial to work closely with your attorneys in both the family law and criminal cases to determine the best course of action. Here's an overview of what the process may look like from this point, based on the information provided. 1. Officer's recommendation. The officer has recommended a hit-and-run charge to the district attorney's DA office. This is not a formal charge yet, but a suggestion for prosecution. 2. DA's review. The DA's office will review the officer's report and recommendation. They will decide whether to file formal charges or not. This decision is based on the evidence and the likelihood of conviction. 3. Possible outcomes at this stage. A. The DA may decide not to file charges if they believe there's insufficient evidence or mitigating circumstances. B. The DA may file formal charges for hit and run. 4. If charges are filed, A. You will receive a summons to appear in court for an arraignment. B. At the arraignment, you'll be formally informed of the charges and asked to enter a plea, guilty, not guilty, or no contest. 5. Legal representation. It's advisable to consult with a criminal defense attorney at this point if you haven't already. They can guide you through the process and help protect your rights. 6. Further proceedings. Depending on your plea and the specific circumstances, there may be A. Pre-trial conferences, B. Plea bargaining negotiations, C. A trial if the case proceeds that far. 7. Potential penalties. If convicted of hit and run in California, penalties can include fines, probation, and possibly jail time, depending on the severity of the incident and any prior offenses. It's important to note that your explanation of the circumstances, near miss with another car, concussion, dead phone, may be considered mitigating factors. However, leaving the scene of an accident is still a serious matter in California law. Given the potential consequences, it would be wise to consult with a criminal defense attorney who specializes in traffic offenses in California. They can provide more specific advice based on the details of your case and guide you through any legal proceedings.